Good morning, everyone. Thank you for taking time to attend this morning's webinar. We encourage everybody to ask some questions. You can use the field at the bottom of your screen to send us questions during today's webinar. We'll answer as many of those questions as we have time for. If we don't get to your question, we'll follow up with each of you at the completion of today's webinar. The webinar will be recorded and posted to our website on our cybersecurity page, www.iaofil.org/cyber. This is our third webinar in a series of 4 covering cybersecurity and data breaches. In our previous 2 webinars, protecting your agencies as well as your personal financial survival, we've discussed the personal financial exposure an agency has to a data breach. As we said previously, this is a very real possibility and an urgent issue which must be addressed by every agency and agency owner. We hope that through these webinars and CE class, the needs of our members will be addressed and that our agents will understand the gravity of the situation. We believe that through the use of this information, we can provide our members with the tools to protect themselves and their agencies from the potential financial fallout from this exposure. Our webinar today will review your agency contracts, specifically their data privacy and security requirements, and how this can affect the financial future of your agency. As we discussed in the last 2 webinars, the Independent Agents Council for Technology, or ACT, has determined that the potential exposure to its agency members was so severe that they developed the Agency Cyber Guide 1.0, which has now been updated to the Agency Cyber Guide 2.0. The introduction states the following. Handling sensitive information is now one of the most critical responsibilities faced by the modern insurance agency. Independent insurance agents and brokers must properly collect and protect sensitive client information every day. This means they must comply with state and federal regulations with regards to privacy laws, as well as adhering to customer service best practice standards. These acts and regulations can be difficult to address given the responsibilities agents encounter daily, but it has to be a priority. As we stated previously, to help begin this process for your cybersecurity, we've partnered with Bill Larson of NetGen Data Security Consulting and Profit Protection Risk Management Consulting to help guide us through the process. This is the third in a series of 4 webinars that Bill and I will present on the topic. We'll also provide a 2-hour CE course encompassing the 4 webinars at this year's convention. Bill has worked closely with IABA over the past 7 years. Bill is a major contributor in developing the ACT Cyber Guide 1 and 2.0, which he presented at the National ACT Conference in Chicago. Bill is a member of the IABA ACT Security Issues Work Group, which is working on the development of the ACT Cyber Guide 3.0. Bill is also chairman of the IAB ACT HIPAA Work Group, which leads the study of compliance and liability exposures associated with data privacy laws and the independent insurance agents. Bill has also co-authored articles on data privacy and security for various insurance publications and worked with other state associations on the topic. Bill, can you get us started on today's topic of carrier contract review?
Sure, Brian. Yeah, tell you what, it is good to be on our third webinar. So we're working through this for everybody. As we stated in the last webinar, today we will review your agency contracts as to their data privacy and security, compliance requirements, and how this will affect you and your agency. The language is contained in every agency contract. Now, these contracts are executed both corporately and personally, and if your agency is not compliant with these laws and your insurance carrier incurs a loss due to your negligence by contract, your agency is required to reimburse the carrier for all their losses. And in today's webinar, what we will do, we will discuss the steps that you can take in your agency so you can avoid this potential financial disaster. Now, a lot of what we'll discuss today comes from the webinar and white paper we did for Big I, that's IIABA Act a couple of years ago. And both the white paper and the webinar are posted on IIABA's website. And this will be provided for you on the IIA of IL website under www.iiaofil.org/cyber. That will be next to the ACT Cyber Guide 2.0 link. Now, the title of the white paper is Insurance Company Agency Agreement Language That Could Drain Your Agency Assets. How much money do you have in your wallet? So again, obviously, what we're trying to do is get the agency owner's attention so that they can begin to understand their problem and begin to take some preventative action. Now, the insurance company agency agreement wording for both property casualty agents and group health agents require the following: unequivocal compliance with all current state and federal privacy and data breach response laws, and failure to do so puts the agency in potential breach of contract. And the agency could become liable then for all claims incurred by the insurance company under the indemnification clause in their agreement. And this could cause very serious financial harm for most agencies and agency owners.
Bill, most of those contracts contain an indemnity clause as well. Could you talk about that a little bit?
Yeah, the indemnity clause is critical in this whole situation, and obviously, since it's by the insurance company, tends to be very, very one-sided. It typically requires that the agency hold the company harmless for any claim, demand, liability, dispute, damage, cost, expense, or loss, including reasonable attorney's fees and the cost of litigation, which arise as a direct result of the acts, errors, and omissions and negligence of the agent. So, following an extensive review of different company agency agreements, this was done at the request of the Big I, in other words, IABA Act Division. And what we did, we reviewed over 100 company contracts, and the findings showed that all property casualty insurance contracts require the agent to be compliant with federal and state laws. The major laws we discussed are Gramm-Leach-Bliley and the Illinois Personal Protection Act. Again, in reviewing these privacy laws, it is important to point out that failure to comply with the agency would put them in breach of contract, and the likely cost of the insurance company would be the responsibility of the agent. So the agency would likely also face fines and penalties levied by state and or federal government agencies. So in other words, the numbers could be so significant that it caused no other alternative than to declare bankruptcy, not only for the agency, but could impact the owner's personal financial position as well. So agency and insurance companies' relationships, again, begin and end with the agreement that exists between them. And despite any advances in agency company agreements, very unfortunate trends continue to be in play. So first of those unfortunate events are the failure of agents to pay much attention to what they're signing, either from a new insurance company contract or an updated contract with the current company. Secondly, that agencies do not pay attention to or put much credence into addendums that are attached to the original company agreements where a signature is rarely required.
Bill, we discussed Gramm-Leach-Bliley Act in our previous webinars. Could you review those basics again for everyone?
Sure. As we discussed in our previous webinars, Gramm-Leach-Bliley is a very robust law, and GLBA applies to all insurance agencies. So if an agency is to protect itself from fines, penalties, and the possible breach of contract provisions within the insurance companies, the agency must comply with the agency company agreements and, by extension, any other relevant laws. So consequently, to avoid a breach of their agreement and become liable for the costs incurred by the company, the agency must protect their customers' data described as non-public information. This requires the agency to have three distinct plans: a privacy plan, a security plan, and a data breach response plan. The Gramm-Leach-Bliley Act requires agencies to give consumers privacy notices that explain the agency's information sharing practices and to explain how their clients' non-public information will be protected. Now, most agencies have really not done a very good job in this area, since all new customers must get a paper notice and then the agency must place their privacy notice on their website. Now, most agencies simply only post on their website. Now, unfortunately, the actions which are stated in their notices, which again are placed on their websites, are minimal at best, and in most cases are not completed at all. So, most privacy notice state the following. It says, our agency, as a member of the financial services industry, has been and continues to be subject to federal and state privacy laws regarding the collection and exchange of your insurance information. Our agency exchanges your information only with other insurance-related parties that are similarly obligated under state and federal privacy laws to have in place appropriate procedures to protect your information with the requirements of these laws. So again, these practices must comply with the requirements of the laws. And then it says our agency maintains physical, electronic, and procedural safeguards that comply with federal regulations to guide your non-public information. The problem very simply is that most agencies are not compliant with Gramm-Leach-Bliley, and therefore, one, are in breach of contract with their agency company contracts, and secondly, are subject to the financial penalties associated with these agreements.
Bill, could you talk about those financial penalties associated with those contracts?
Sure. What will happen is, first, those penalties will go as follows, and we'll list 5 of these. First is pay all cost of the investigation by the company, both of the agency as well as the cost of a possible national investigation, since the breach had originated at the agency level. Next, pay all cost of the required notifications by the company. Third, pay all costs of attorney's fees which are accrued by the company. Then pay all defense and liability costs accrued by the company. And fifth, pay any additional costs accrued by the company as a result of the agency's signed agency agreement. So, based on the insurance company language, if an agency is found to be the cause of a data breach through negligence, the cost, expense, fines, penalties really could be a death wish for the agency, with the possibility of extending this to the agency owner. So, not a position you want to be in. So again, in any event, it will be a drawn-out, costly process with the likelihood of the agency being pushed out of business. So, as we stated in our previous webinars, the Gramm-Leach-Bliley Act is made up of 12 major sections, as stated in the IIAB Act Cyber Guide 2.0. And these 12 I'll run through very quickly, as we've discussed these before. So first is risk assessment, then written security policy, an incident response plan, staff training and monitoring, penetration testing, access control protocol, written security policy for third-party service providers, encryption on non-public information, designation of a chief information officer, audit trail development, implementing multi-factor authentication, and finally, procedures for the disposal of non-public information. So most of you use the IIA of Illinois sample privacy policy for your website requirements. And in my opinion, this is an excellent notice and addresses the requirements of your agency for the data policy disclosure and protection as defined by Gramm-Leach-Bliley. Now, under the IIA of Illinois sample policy statement, you have stated that you're a member of the financial services industry and subject to the privacy laws regarding this industry. You also have stated that you exchange information with other entities which have in place the appropriate procedures as required by these laws. You have also stated that you maintain physical, electronic, and procedural safeguards that comply with both federal and state privacy laws in guarding your client's non-public information. So unfortunately, most agencies do not have in place either a contract with third parties to whom they send their clients non-public information, nor do most agencies have the procedural safeguards in place, nor are they compliant with the 12 requirements as we just reviewed in the Gramm-Leach-Bliley Act. And this easily places the agency and the agency's ownership in breach of their company's contract and opens the doors to potentially significant financial problems. So when it comes to the investigation of a data breach, state and federal regulatory agencies will do the following. First, they will review the agency statements which are posted on our website. And secondly, they will then audit to determine if the agency had implemented all of the items as stated in their privacy statement.
Bill, you previously mentioned the Illinois Personal Information Protection Act. Could you explain how this act would affect our agencies?
Sure. With regards to the Illinois Personal Information Protection Act, it states the following, and I'll just read part of it for you. The Act requires companies and organizations with personal information of Illinois residents to implement and maintain reasonable security measures to protect data from unauthorized access, acquisition, destruction, use, modification, or disclosure. The Act requires any contract under which one company transmits personal information to another company to include a provision requiring the recipient of the information implement and maintain reasonable security measures. So basically, what it's saying, it's just as we have stated in GLB. So then we go on, it says the Act also provides that a violation allows consumers to sue offending company and organization under the Consumer Fraud and Deceptive Businesses Protection Act. So again, in my opinion, this alone would be reason to become compliant with these laws and purchase a quality data breach policy. So while most agents' contracts specifically identify GLB and state-specific data privacy laws, others will state just, federal and you have to be in compliance with federal and state law, privacy and security laws. And again, really either way, the intent is the same thing, and it's just privacy compliance. Now, failure to adhere to these provisions puts the agency and the agency owner in a position of breach of contract, as we've talked about. So since none of the agency's insurance policies, such as errors and omissions or general liability, would provide breach contract coverage, this could be financially devastating to the agency. And if the breach of contract was invoked by the insurance company and the agency were found to be at fault, this could be extremely serious.
Bill, could you review some specific agency contracts and the specific requirements agents must do to comply with the contractual language?
Sure, and again, it all comes down to the agency contract. And in our last webinar, we briefly reviewed two agency contracts which defined what we've just said. The first one we discussed was a recent addition to an existing agency contract from a large national insurance company, which I believe many of the members represent. And it states the following, and again, I'll read this to you. It says, you agree to purchase, keep in force and effect, and maintain at your own cost during the entire duration of the agreement a cyber insurance policy with limits of $1 million per claim and $1 million per aggregate, covering loss arising out of media liability, network security liability, privacy liability, privacy regulation proceedings, including any resulting fines and privacy event expenses, including forensic costs to determine the nature and extent of a breach, computer and data loss restoration, voluntary and mandatory notification costs, and credit monitoring services. And it goes on to say, you warrant that you have in place reasonable controls to protect personally identifiable information, and you warrant that you have provided training for your employees, agents regarding appropriate cybersecurity. And again, it goes on and says, The producer represents and warrants that as of the date of this amendment and continuing through the terms of this agreement, it complies with all applicable cybersecurity laws and regulations. The producer represents and warrants that its security program is in effect to protect, and here it names the insurance company, their information systems and non-public information. So again, as you go through this whole thing, the word warrant is in here, and this is very, very definitive. If you warrant something, there's really no way you're going to get out of that. The second one here is in our last webinar we discussed was from a large regional mutual insurance company. And again, many of you have contracts with this company. And again, I'll read what it says here. The agent will defend, hold harmless, and indemnify the company against liability, including the cost of defense and settlements imposed on it by law, including and without limitation, the Fair Credit Reporting Act and the Illinois Privacy Act and any other applicable privacy law for damage sustained by policyholders and caused by acts or omissions of the agent. So again, failure to adhere to these provisions puts the agency owner in a position of breach contract, since it's not likely, as we've discussed, any of the agency's own policies would provide breach of contract coverage. So again, this would be devastating to the agency and the agency owner if a breach of contract was invoked by the insurance company and the agency were found at fault. Tell you what, now let's take a few minutes and we can review this type of language. We've got 4 other agreements here. The first one says the agency will comply with all applicable privacy laws regarding the access of or disclosure of the information provided. So again, all laws such as GLB and the Illinois Privacy Act must be complied with. Next one says the agency will indemnify and hold harmless company and any affiliate, trustees, officer, director, employee, volunteer, or agent from and against any lawsuits, damages, losses, fines, penalties, claims, cause of action, liabilities, costs or expenses, including attorney's fees and court or proceeding costs. Collectively, we're talking about claims arising out of or in connection with the agency's negligence, willful acts, or omissions. So again, this would be defined as, again, not being compliant. Our next one says agency agrees to indemnify and hold, and again, it lists the insurance company here, harmless from any and all liabilities, losses, damages, fines, penalties, expenses, and costs, including without limitation reasonable attorney's fees, which shall suffer, incur, or pay out in connection with any failure by the agency to comply with the terms of this agency agreement. And again, it says in your agency agreement, you must comply with all state and federal laws. So obviously, this restates that. Our last one here says, the agency shall indemnify the company and hold it harmless from any and against all penalties, losses, claims, damages, liabilities, or actions in respect thereof, to which the company may become subject insofar as such penalties, losses, claims, damages, or liabilities, or actions in respect thereof that arise out of or based upon any breach or unauthorized use of disclosure of confidential information by the agency, including its employees, officers, directors, agents, and or subcontractors. And again, we've talked about subcontractors is a big deal here. These excerpts from the various insurance companies clearly state that this intends to mean that the agents are aware that they are liable for the criminal and civil penalties associated with this agreement. And again, big deal. A lot of people have blown this thing off. This is extremely serious, and this is why we're talking about this. The hold harmless and indemnification wording has specifically been placed in these agreements by the insurance company's legal department to protect them by transferring some of the liability exposure to the agency when a data breach appears to be the fault of the agency. And again, it's affiliates, vendors, or business partners. So be very, very careful what you sign here.
Thanks, Bill. That was some great information. I hope our members put into practice within their agencies. What are you going to be talking about in our next webinar?
Okay, as we progress along here, as I said before, the Big I, Independent Insurance Agents and Brokers of America, through their ACT division, has determined that the potential exposure for an agency was so severe that they, again, developed, as we talked about in the first part of the program, Agency Cyber Guide 1.0, which is now being updated to 2.0 and soon will be updated to 3.0. So we're continually developing this program for the agencies. The introduction states the following: handling sensitive information is now one of the most critical responsibilities faced by the modern insurance agency. So again, this means that they must comply with all state and federal regulations with regards to privacy laws. So again, in our next webinar, we will use the Agency Cyber Guide 2.0 as our study guide to help your agency to become compliant with the contract wording in your agency contracts and help mitigate your financial exposure, or hopefully mitigate your financial exposure to the liability situations which these requirements present to you and your agency.
Great. The next webinar on the Cyber Guide will be October 16th, and we'll review in depth the steps in the Cyber Guide 2.0 and how this can provide the beginning of your journey to get your agency into compliance and protect the financial future for you and your agency. Again, we've provided exceptional products for our members to help to be compliant with current data privacy laws as defined in your company contracts and with current federal and state laws. You can go to our website, cyber page, iaofillinois.org/cyber. You can also contact Bill at NetGen Data Security to discuss any questions, and he's got a toolkit that will help you begin the process. In order to help you implement your cyber liability, one of those risk management components, of course, is the cyber liability policy. We're offer 3 different policies to our members through Beasley, Evolve, and Coalition. If you're interested in any one of those 3, you can review those products again on our cyber page, iaofillinois.org/cyber. We have had a couple of questions come in over the last 20 or 30 minutes. So I think we have time to get to a couple of them. Bill, the first question is, are there other agreements within my agency that I should be aware of that might contain compliance agreements? I'm guessing maybe they're agency management systems, maybe they're if they use a payroll service or something like that.
Yeah, virtually every entity is doing something like this. So let's say we're doing some E&S work. You may have a contract out there. Obviously, agency management systems. Let's talk about that just for a second. At that point, I have not seen any agency management system contract that will have them accept the responsibility for a breach while they have the information. So again, when you sign that contract, you're still providing coverage from the standpoint that you have in effect put something in place with that agency management system. Again, a contract that says that the non-public information will be protected, and then obviously through their contract it says that you're going to protect it. So again, make absolutely sure what you sign out there. But again, everything you sign coming down from at least what I see here on out has some form of this language in there. So what it's doing, it's making sure the agent has this information in place, because these other entities do not want to become liable for your miscues, if you will.
Okay, thanks, Bill. The next question, kind of, I think you touched on it, and we probably did earlier in the webinar. Some of my some of my hard to place accounts are written through MGAs. Would they have compliance requirements in their contracts?
Yeah, I mean, when you look at the MGAs, same situation applies. They don't want to be responsible for your problems. So in most cases, they will run the same language that's in your agency contracts with your companies, saying that you're going to put all this stuff in place and you're responsible for it. And if they get involved in it, you're going to cover their costs. So again, this is all coming back down to the agent and agency, that they must be compliant with these data privacy laws.
Okay, thanks, Bill. Looks like we're a little past 30 minutes. So I just want to thank everybody for attending today's webinar. Don't forget our convention coming up the first 3 days in October, and hope to see all of you there. With that, thanks again for attending, and have a great day.